5 gun law changes now taking effect in 2026. Every concealed carry holder must know now, one of the biggest financial barriers in federal gun law has officially been removed. The $200 tax stamp fee for items regulated under the National Firearms Act, NFA, is no longer required. This applies to suppressors, short-barreled rifles, SBRs, short-barreled shotguns, SBSs, and other NFA-regulated items. For many gun owners, this is a long-awaited win. If you've been holding off on buying a suppressor or an SBR, the upfront cost is now significantly lower. The change became law last July and is now fully in effect. However, nothing else has changed. You must still register all NFA items with the ATF. The process remains the same and includes submitting fingerprints, a passport photo, passing a background check, and filing the required Form 4 before taking legal possession. There are no refunds for anyone who paid the fee before the deadline. If you already submitted your application and paid the $200, that money is not coming back. Be careful with dealer pre-orders. What matters is the date your Form 4 is officially submitted to the ATF. If it was filed before January 1st, the fee still applies. Make sure your paperwork is submitted after the change took effect. State laws still apply. Suppressors and other NFA items remain illegal in states such as California, New York, New Jersey, Massachusetts, Hawaii, Illinois, Rhode Island, and Delaware. While the federal fee is gone, possession in those states is still illegal. This is a financial benefit, not a speed boost. Approval times remain 3 to 6 months. And penalties for unregistered NFA items are unchanged. Up to 10 years in federal prison and fines of up to $4 million. Enforcement is not easing, only the fee has been removed. Bottom line, save the money, but follow the rules. File correctly, check your state laws, and don't cut corners. Check your state laws and make sure your paperwork is airtight. A major federal change took effect on November 1st, 2025, and many gun owners are still unaware of it. The U.S. Sentencing Commission updated federal sentencing guidelines, significantly increasing penalties for firearm-related crimes. One mistake can now cost you up to a decade in federal prison. Crimes affected include straw purchases, lying on background check forms, and illegal firearm transfers. These are not minor changes. On a straw purchase, buying a firearm for someone who cannot legally own one has always been a felony. Previously punishable by up to 5 years, it can now result in up to 10 years in prison. The ATF is aggressively enforcing these laws using background check data, surveillance footage, purchase records, and even social media. In 2024 alone, more than 300 straw purchase cases were prosecuted, and that number is expected to rise. Another major risk involves lying on Form 4473, especially regarding marijuana use. Even if marijuana is legal in your state, it remains illegal under federal law. Checking no while using it is a felony. The penalty has increased from 2 years to up to 5 years in prison. The ATF is cross-checking medical marijuana registries, arrests, DUIs, and online posts to identify false statements. What you should do: never buy a gun for someone else. Regardless of relationship, answer every question on Form 4473 truthfully. Understand gifting laws before transferring a firearm. Giving a firearm to a prohibited person, even a family member, is still a federal crime, and penalties are now much harsher. Colorado new requirement starting August 1st, 2026. Colorado gun buyers must complete state-approved training and obtain a permit before taking possession of a semi-automatic firearm. This applies to AR-15S, semi-auto pistols, and tactical shotguns. The law does not ban these firearms, but adds a mandatory step to the purchase process. The training must be at least 4 hours, taught by a certified instructor, and include firearm safety, storage, Colorado laws, and a live fire qualification. Simply attending is not enough. You must demonstrate competence. If you already have a valid Colorado concealed carry permit, you are exempt. If not, expect costs between $75 and $150, plus range fees and gear. Plan ahead, as class availability will be limited. Bottom line, the laws didn't just change, the punishments got much more severe. Mistakes that once carried light penalties can now result in years in federal prison. Know the rules, follow the process, and don't take shortcuts. Semi-automatic semi-automatic firearm in Colorado before August 1st, you're grandfathered in. You do not need to get a permit for a semi-automatic firearm you already own, but that protection ends the moment you try to buy a new one. The permit issued after completing training will be valid for 5 years. After that, renewal requires a refresher course. This is not a one-time requirement, it's ongoing. The Colorado Bureau of Investigation, CBI, is currently certifying instructors, and the official approved list will be published by June 1st. Make sure your training is completed with an approved instructor. If not, your certificate will not count and you will have to repeat the course. Colorado residents. If you already have a valid concealed carry permit, no further action is required. If you do not and plan to buy a semi-automatic firearm in 2026, start looking for a certified course now. Class availability will be limited, especially by midsummer. After August 1st, 2026, taking possession of a semi-automatic firearm without the required permit is a Class 2 misdemeanor, punishable by up to 120 days in jail and a $750 fine. Dealers are also liable for transferring firearms without verifying permits, so strict compliance from gun stores is expected. This law is finalized and enforcement is coming. Kentucky Red Flag Law, ERPO. Starting February 1st, 2026, Kentucky will enforce one of the most expansive extreme risk protection order, ERPO, laws in the country. This law allows courts to temporarily suspend firearm ownership and concealed carry rights without any criminal charges. Petitions can be filed by current or former spouses, recent partners, family members, roommates from the past year, or any law enforcement officer. The legal standard is reasonable cause, meaning the judge does not need clear evidence, only a credible claim of potential danger. If approved, firearms must be surrendered within 24 hours. And carry privileges are immediately suspended, often before the individual is even aware the order was filed. A hearing is provided within 14 days, but during that time, possession of firearms is illegal. If the order becomes permanent, restrictions can last up to 1 year and may be renewed. Violating an ERPO is a Class D felony, punishable by 1 to 5 years in prison. Firearms are not automatically returned after the order expires. A court request is required. If you live in Kentucky, know who can file an ERPO against you. Keep records during disputes or conflicts. Hire a lawyer immediately if served with an ERPO. This is one of the most aggressive gun control measures Kentucky has enacted, and its impact on lawful gun owners will be significant. It's just weeks away from going live. But while the goal of the law is framed around safety, the impact on lawful gun owners, especially those unaware of their risk, is significant. And Kentucky isn't the only state making major changes. A federal bill on the horizon could reshape concealed carry nationwide. That bill is the Constitutional Concealed Carry Reciprocity Act, known as HR 38. If it becomes law in 2026, every state would be required to honor concealed carry permits issued by any other state. This would be the largest nationwide expansion of carry reciprocity to date. Right now, reciprocity laws are inconsistent. Some states recognize dozens of permits, while others recognize none. For example, Texas honors permits from 42 states and Florida from 38, but carrying legally into states like California, New York, or New Jersey can still result in felony charges. HR 38 would change that by treating a concealed carry permit like a driver's license, valid in all 50 states without additional state-specific requirements. As of now, HR 38 has been reintroduced with strong support, 213 House co-sponsors, and is currently in the House Judiciary Committee. If it passes the House, it would move to the Senate, where similar bills have historically stalled. Even if passed, legal challenges from restrictive states are likely. HR 38 is not law yet. Until it is passed and upheld in court, gun owners must continue following current reciprocity rules. Anyone traveling with a concealed firearm should check reciprocity laws carefully and consider non-resident permits from states like Florida, Utah, or Arizona. 2026 Gun Law Action Plan, January 1st, 2026. The $200 NFA tax stamp is eliminated. Suppressors and short-barreled firearms no longer require the fee, but proper registration is still mandatory. February 1st, 2026. Kentucky's Red Flag ERPO law takes effect. Know who can file an order and how to respond. August 1st, 2026. Colorado requires training and a permit before purchasing any semi-automatic firearm. November 1st, 2025. Federal sentencing enhancements for straw purchases and false statements on Form 4473 are already in effect. Final takeaway: if you live in or travel through states like Colorado or Kentucky, or plan to buy a firearm or NFA item, now is the time to to understand the new laws. Start NFA paperwork in 2026 to avoid unnecessary fees. Follow all registration rules and always be truthful on Form 4473. Never make a straw purchase. Penalties are harsher than ever, and the consequences are real.